Good morning, everybody. A few years back, let me just check and make sure that everything's going as it should do. You know the routine by now. I like to make sure that I'm able to monitor what's coming up on screen. 2 seconds. Sure. Yeah, everything seems to be fine. So as I was saying, a few years back, the local church here in Dassey, St. John's, we were without a minister. And as a result, every Sunday, a different minister would come from as far away as 30, 40 miles away sometimes. One or two were regular ministers that came along, the more local ones. But occasionally we'd have a really fine gentleman come up from Jedburgh, whose son is a famous border MP. We had people come across from Peebles, 20 miles away, from Kelso and surrounding areas. And one day we had a gentleman come down from Edinburgh, and he said in his sermon about the need to sort of continually do, in effect, a retrospective of where we're at. And he gave as his comparison a really great story, which I really do hope that this is genuinely the case. And if there's any golfers out there, maybe you can confirm this. But the legendary golfer Jack Nicklaus used to, during the sort of close season, when the tournaments had finished and he'd got a few months off, he would drive from somewhere like New York down to Florida to meet up with the coach, his trainer that he had when he was just starting out. So he's the sort of world champion of golf at the time. But every year he would travel down to Florida and meet up with his coach that he had when he was a youngster. And just one moment. Sorry about that. He would go along to the golf club with his coach, his coach of many years, and he would literally hand over the golf clubs to his coach. Remember, this is the greatest player in the world, and he would hand his golf clubs over to his coach, and he would say to him, "I want you to teach me how to play golf." And it was just a way of going back and looking, sort of, as I say, a retrospective, looking back, going back over everything, making sure that everything is correct about his game. So I thought it'd be a nice idea to really hopefully to clarify some of the sort of facts about this case, and going back to the decision by Judge Jerome Fox at the appeals court stage, which of course is quite interesting because we are now at that stage with Stephen, and of course Richard Leo we've recently had on Eric Ozzy's channel, and I've done some articles about Richard Leo and about his affidavit, which is referenced obviously by Judge Jerome Fox. And if I'm being perfectly honest, what Jerome Fox has written, some of it makes perfectly good sense. It seems quite fair that what he's saying when he's sort of explaining the legalities of the situation. That seems rather seems rather fair. Reminds me a little bit of Mike Griesbach's book The Innocent Killer. The first 2/3 very, very good. But then you get the conclusion at the end, which is completely wonky, to use Brendan and Eric Ozzy's technical terms. Sorry, this is coffee. I couldn't find the dude's whiskey. It's here somewhere, but it's a bit early in the morning as well for swigging scotch. kind of reminds me of people in examinations, and when they get their marks back, pupils that have done exams, they'll get their mark back, and they'll look at the mark, and then they'll look at the notes, you know, the comments by the examiners, and the examiners have sometimes written 4 very, very nice sentences about the good points of the tune, but have only given them what the candidate sees as being a low mark. I've seen this in competitions as well, when the adjudicator gets up and summarizes the performances, and the winner ends up with comments to the fact that it seems as if there were a lot of things to improve on. So you think, well, somebody else has been given a load of nice comments, and they are not they're not placed first. So anyway, I think we'll take, as I say, Judge Jerome Fox's comments with a little pinch of salt here. Hello, Victor Davis. How are you doing? I mean, there's no doubt about it that both Jerome Fox and Patrick Willis are incredibly concerned about re-election in their rural Manitowoc County. And as I said before, I am under no illusion that none of these judges want to have high-profile cases like Stephen Brendan come in front of them, and they be regarded as one of the reasons why either of them were acquitted, because of their rulings within their court. I think we've seen, don't we, that the judges bend over backwards. That horrific statement by Judge Willis to Stephen, that you are the most dangerous person ever to enter this courtroom. I can't help thinking that Patrick Willis, you were addressing the wrong person. You should have been addressing those comments to Ken Kratz. But anyway, let's have a look, as I say, a bit of a retrospective, and look at where how the appeal process started off. As I say, we've looked at the affidavit of Dr. Richard Leo, and if you haven't, easy to look it up. It was just about 2 weeks ago, and then we had a live chat with Richard Leo on Eric Hosey's channel, which is why he allowed me to use his studio this morning, because he's fast asleep. Anyway, let's have a look at the particular decision by Jerome Fox. As I say, some of it seems, dare I say, well written, well presented. The sort of work that a competent judge should be capable of. Which gives this illusion that he's being fair and reasonable. Anyway, here it is: the state of Wisconsin versus Brendan Raymond Dassey, case number 06 CF 88. I say this we'll split it into probably a few parts. It's quite a lot that I want to actually go through. Anyway, introduction. The defendant, Brendan Dassey, who from now on we'll refer to as Dassey, was charged on March the 3rd, 2006, with being party to the crimes of first-degree intentional homicide, second-degree sexual assault, and mutilation of a corpse. The victim in all 3 charges was Teresa Holbach, who was murdered on October the 30th. October the 30th? You mean she was actually murdered the day before Halloween? Judge Fox. This is an incredibly important decision that you're writing, and you can't even get the right date. Beggars belief. Was murdered on October, well, he should have written October 31st, 2005 in Manitowoc County. In a separate trial, Dassey's uncle, Stephen Avery, was convicted on March 18th, 2007 as being a party to the crime of Teresa Holbach's first-degree murder and being a felon in possession of firearms. Jury selection for Dassey took place over a day-and-a-half period in Dane County. The court ordered Dassey's jury sequestered in Manitowoc, and his trial began on April the 16th, 2007. It concluded on April the 25th, 2007, when the jury returned guilty verdicts to all 3 charges. On August the 2nd, 2007, this court sentenced Dassey on the intentional homicide conviction to life in prison with the possibility of release to extended supervision on November the 1st, 2048. Additional concurrent sentences were given for the other 2 convictions. Now, Dassey filed a motion under Wisconsin Statutes 809-30 on August the 25th, 2009, seeking post-conviction release. That's over 2 years later. Okay. Specifically, Dassey is seeking a new trial or a new suppression hearing. So this is stamped as having been received December the 15th, 2010. Was there not something else memorable around about that time? Was it not around about that time that the bones were being handed back? And the heat was just about to be applied to Ken Kratz for his sexting. So, sorry. Bizarrely, we go from this line. He alleges he is entitled to this because his trial counsel, Mark Fremgen and Ray Edelstein, and attorney Leonard Kachinsky, meow, who represented him immediately before trial counsel was appointed, were ineffective in their representation of him. So this is interesting because, in effect, Steve Drizzen and Laura Nyrider are going after Fremgen and Edelstein. And I think we discover something quite interesting about Fremgen and Edelstein in the fact that they didn't agree on one aspect of the strategy in this case. Okay. He also requires a new trial in the interest of justice because, he alleges, the real controversy was not fully tried and his conviction represented a miscarriage of justice. The real controversy, could that be the reference to the false confession, or is that referring to the fact that obviously, Brendan Dassey was the collateral damage of Stephen's case? Anyway, lastly, Dassey asks for a new hearing on the suppression of his March 1st, 2006 confession. So, as I say, the real controversy, I'd like to know what that specifically is referring to. Okay, a motion to suppress those statements was originally heard by this court on May the 4th, 2006, and denied in a decision given May the 12th, 2006. Subsequently, a motion to reopen the hearing to suppress statements was filed by successor trial counsel. The court denied that motion on December the 15th, 2006. Dassey's post-conviction motions were heard by this court over a 5-day period, beginning January the 15th, 2010, and ending January the 22nd, 2010. No hearings were held on Martin Luther King Day, January the 19th, 2010. Following the close of defendant's post-conviction case, the state waived its right to call witnesses on its behalf. The court ordered a briefing schedule for the parties, and those briefs have been completed and received. The court's decisions the court's decision follows. Standard of review: ineffective assistance of counsel. Now, Dassey was represented by attorney Len Kachinsky from March the 8th, 2006 until August the 25th, 2006, when this court found his performance as counsel for Dassey to be deficient as a result of his failure to attend a police interview with his client, which Kachinsky had arranged. Attorney Mark Fremgen was appointed successor counsel on August the 29th, 2006. Attorney Ray Edelstein joined Fremgen as co-counsel for Dassey. All counsel were appointed through the Wisconsin State Public Defender's Office. Dassey's post-conviction motions allege each counsel ineffectively assisted him, either singly or collectively, and their deficient performance entitles him to the relief he is seeking. To establish an ineffective assistance of counsel claim, Dassey must show that counsel made errors so serious that counsel was not functioning as the counsel guaranteed the defendant by the Sixth Amendment, and that counsel's errors were so serious as to deprive the defendant of a fair trial, a trial whose result is reliable. So this is the Strickland versus Washington, which is obviously we hear a lot about this Strickland case of 1984. The court need not address both components of this inquiry if the defendant does not make a sufficient showing on one. Deficient performance requires a showing that counsel's representation fell below an objective standard of reasonableness. The court reviews the attorney's performance with great deference, and the burden is placed on the defendant to overcome the strong presumption that counsel acted reasonably within professional norms. State versus Johnson, 1990. An attorney's performance need not be perfect, nor even very good. Well, it was certainly far worse than that, to be constitutionally adequate. State versus Carter. When evaluating effectiveness, the court grants a heavy measure of deference to counsel's judgments. A defendant that can demonstrate counsel's performance was deficient must also show a reasonable probability that the deficient performance had an adverse effect on the outcome. Generally, when a defendant accepts counsel, the defendant delegates to counsel those tactical decisions an attorney must make at trial. To show prejudice, the defendant must demonstrate that there is a reasonable probability that, but for counsel's unprofessional errors, the results of the proceeding would have been different. Strickland, the burden of proof is on the defendant to show by clear and convincing evidence that both components of the ineffective assistance of counsel test have been met. Okie dokie. State versus Lukasik. No, I'm monitoring it and it seems to have gone all black. So I just want to make sure that. No, I don't know what's happening there. Just one moment. We'll come back. Just want to make sure that everything is hunky-dory as it should be. Well, it seems to be okay, but on my screen, it's gone all black. Anyway, not to worry. Hopefully everything is okie dokie. So let's go back then to State versus Lukasik. Yeah. Okay. Attorney Len Kachinsky's ineffective assistance of counsel. Let me just try this. His breach of loyalty to his client. Dassey, well, I don't think there's any doubt about it, but anyway, let's see what Judge Fox decided, or at least we'll get his decision at the end. We know his decision. It's obviously painful to read this, knowing that he decides against Brendan. It was only until we got to Duffin and Williams, Rovner, that we finally get some sensible opinions. His breach of loyalty to his client. Dassey urges this court to find that Kachinsky's actions on behalf of his client constituted disloyalty to the client and amounted to a conflict of interest. He sets forth in his brief a series of things Kachinsky did or that were done at his direction, which Dassey says justify his claims that Kachinsky was disloyal and furnished him with ineffective assistance of counsel. He starts with statements Kachinsky made to media even before meeting Dassey, in which Kachinsky seemed to imply that Dassey may have had some involvement in the Holbach murder. This brief notes other instances of remarks made by Kachinsky to the press, which again implied that Dassey had some involvement in the crime for which his uncle, Stephen Avery, was also charged. In his post-conviction testimony, Kachinsky admitted talking to the press about his client's possible involvement in the crime, but said he did so in part to blame Stephen Avery and in part to send a message to the family that Dassey might have to take a, quote, legal option that they don't like. Dassey goes on to cite what he believes are additional instances of Kachinsky's disloyalty. Chief among them is a confession extracted from Dassey on March 12, 2006 by Michael O'Kelly, an investigator employed by Kachinsky. The admissions made by Dassey followed a lie detector test administered to Dassey by O'Kelly, and which O'Kelly told Dassey he failed because the test showed a 98% probability of deception. Well, I'm sure, as you all know, the actual result of that test was that Brendan passed it. Anyway, after some prefatory prodding, never heard that one. Anyway, okay, let's after some prodding and cajoling by O'Kelly, Dassey went on to make a series of incriminating admissions. Yeah, he kept saying, and created a number of drawings depicting events that he was describing. That's interesting, isn't it? There was a great comment by Big Jeff who pointed out that when they got Dassey to draw, Brendan, to draw the picture of Teresa on the bonfire, he draws Teresa as a complete person. And yet we know that the body was dismembered and then burnt. And, you know, by the fact that we've got the cut marks, you know, the cut marks would not have been done afterwards. So it was a very interesting comment by Mr. Big Jeff. Anyway, Dassey also points to Kachinsky's direction of O'Kelly to gather additional evidence from the Avery salvage yard, bolstering the state's case against Stephen Avery, even though that evidence would further implicate Dassey. Kachinsky's actions, according to Dassey, even if motivated by a benign intent to secure a favorable plea deal for his client, were neither authorized nor supported by Dassey, who continued to maintain to Kachinsky that he was innocent of any wrongdoing. Dassey argues that Kachinsky's acts were disloyal and represented a conflict of interest, as that term is defined in Coyle versus Sullivan of 1980. Furthermore, once an actual conflict of interest is shown, prejudice is automatic. State versus K, 1982. Now, the state counters Dassey's position by saying that Kachinsky was trying to get the best deal for Dassey, and some of his actions were simply pushback against family members who were fearful that Dassey would testify against Stephen Avery. But again, they're trying to get him, they're admitting that they were trying to get a deal for Brendan. But if Brendan had actually done what was said in that press conference, why would you want somebody as evil as either Steve or Brendan, taking any kind of plea deal? You would simply want to lock them up for life. It does seem very, very twisted. The state characterizes Dassey's May 13th statement given to Fassbender and Wiegert in Sheboygan County without Kachinsky present as a proffer, which could result in a plea agreement. In Coyle versus Sullivan, two privately retained lawyers represented three defendants charged with first-degree murder of two victims. The three were tried at separate trials, and Sullivan was convicted while his co-defendants were acquitted. His appeal, on grounds that his counsel had impermissible conflicts of interest with the multiple representation, was denied by the state courts, but ultimately his conviction was reversed by the federal courts of appeals on his writ of habeas corpus. In vacating and remanding for further proceedings, the Supreme Court held that the defendant, who shows that a conflict of interest actually affected the adequacy of his representation, need not demonstrate prejudice in order to obtain relief. The Wisconsin Supreme Court, in State versus K of 1982, adopting the holding of Sullivan in a case where the defendant claimed ineffective assistance of counsel because he and his co-defendant had been represented by the same attorney. While it denied the defendant's claim of ineffective assistance of counsel, the language of the opinion suggested that it viewed any representation of multiple defendants by a single lawyer or law firm as problematic, and it prospectively required trials courts to make an inquiry on the record whenever that situation arose. The K holding was amplified in State versus Dassey, where the court ruled that specific prejudice need not be shown if the defendant demonstrates by clear and convincing evidence that trial counsel effectively represented a conflicted interest. Counsel in Dassey undertook the representation of two defendants who were charged with commercial gambling. His clients waived in writing any potential conflict of interest and then entered guilty pleas, after which they were sentenced. Their attorney, who represented both of them throughout, urged them to cooperate with law enforcement so that they might avoid federal charges. The court found an actual conflict of interest to exist when an attorney has one client voluntarily supplying incriminating evidence to be used against another client. Dassey believes that the sum effect of what he refers to as Kachinsky's multiple concrete acts of disloyalty warrant a finding by this court that an actual conflict of interest existed, which entitles him to a new trial. Additionally, he contends Kachinsky's acts are egregious enough so that the court should use them to presume prejudice, a presumption which makes unnecessary any inquiry into trial counsel's performance. US versus Chronic. He cites as support for his actual conflict argument State versus Love, where the Supreme Court reiterated the holding in K, while at the same time reversing a Court of Appeals decision which had found on a per se rule an attorney to have provided ineffective assistance of counsel when she represented the state at the defendant's original sentencing. And then months later, working as a public defender, she represented the same defendant at his sentencing after revocation of probation. The court defined an actual conflict of interest as occurring when the defendant's attorney was actively representing a conflicting interest, so that the attorney's performance was adversely affected. Love at 71. No showing of prejudice need be made because prejudice is presumed and counsel is considered per se ineffective. The defendant in Love argued that the per se rule should be extended to cases of serial representation. The court declined to do so and found that on the facts of the case, no clear and convincing evidence was adduced to prove an actual conflict of interest. Unquestionably, Wisconsin courts have recognized that in certain instances, a presumption of prejudice will attach to counsel's representation of a defendant. A number of the instances in which prejudice is presumed are set out in State versus Erickson. The Erickson court opines that these instances are rare, and in the absence of a presumption of prejudice, a defendant must make a showing of actual prejudice, and that the actual prejudice created a reasonable probability that the result of the trial would have been different. Erickson citing Strickland. Dassey relies on Kay, Daddas, Coiler and Love to support his claim that the court should use the per se rule to find Kachinsky's ineffective and grant Dassey a new trial. There are distinct factual differences between Dassey's situation and the conduct complained of in the cases on which he relies. All except Love are instances in which an attorney or attorneys jointly represented more than one client being charged on the same set of facts. Moreover, the lawyer or lawyers involved in the joint representation cases represented their clients from the onset of the case through the plea or trial stage. The court has previously alluded to the factual background in Love, and those facts do not parallel any of Dassey's complaints about Kachinsky's representation, nor do the facts in State versus Franklin. Another case Dassey cites in support for his per se argument. The Franklin court found that the defendant's attorney, who had represented the defendant throughout her proceeding, had placed himself in an actual conflict of interest with his client when he placed his financial interest before his allegiance to the client. Kachinsky's representation of Dassey ceased on August 25, 2006, after this court found that his failure to personally appear with his client at a May 13, 2006 interview with investigators Burt and Ernie constituted deficient performance. This was some 7 months before the actual trial began, with the selection of the jury in Dane County on April 12, 2007. Regardless of how the conduct of Kachinsky and his agent O'Kelly is characterized as it relates to the events of May 12th and May 13th, Dassey must establish that an actual conflict of interest adversely affected his lawyer's performance. Coiler. By the time a jury was selected and Dassey was tried, Kachinsky was long gone from the case. Nothing from O'Kelly's May 12th interview, in which he had Dassey incriminate himself, found its way into the trial record. other than a brief audio clip of a portion of a phone conversation between Dassey and his mother, which the state played without objection in its cross-examination of the defendant, and several questions asked on the cross-examination of Dr. Robert Gordon. Nothing from May 13th was introduced at trial, and the state made little more than passing reference to the May 13th phone call in its closing to the jury. Well, I think we'll just hold it there. And where are we? We're page 9, just at the end of page 9. And there's about 30 pages altogether. So I think that's, yeah, going about 35 minutes. So let's hold it there. I better crack on, do some work. And we'll catch you all very soon. If I get time later on today, I might even do the next bit of this decision by Judge Fox. And hopefully we'll catch you all then. Have a good day, and we'll see you soon. Bye for now.